Hi everyone, Eric Rodebois, EPGD Attorneys at Law. I'm going to do a little bit of a deeper dive on the importance of having the right kind of insurance. And so I'll tell the story. The lady has a car rental business where she owns the cars and she's renting them out. And one of the cars needs some maintenance, so she takes it to a shop. I don't know what her prior relationship with this shop was. It wasn't that much money. I think I saw the invoice. It was for $350. She signed when she turned over the car, and lo and behold, the car over the weekend burns to a crisp and is a total loss. So she goes to her insurance company and just finds out that she doesn't have the right type of coverage. And what she had was renter's insurance, which didn't cover this type of scenario. Now, mind you, insurance companies are always trying to find a reason why they're not going to cover your claim. So then she goes to the mechanic shop, and for whatever reason, she finds out that their insurance coverage doesn't want to cover it. And so she comes to me and she's like, well, what do I do? And I'm like, well, listen, there's really two paths. You can sue your own insurance company if you think that they're wrong. And that's called first-party insurance, where, for example, the classic is there's a hurricane and the tree falls on your house and you get the adjuster out there and the insurance company is willing to give you $1,000 when it's really $100,000. And so when that happens, what you do is you have to hire typically a lawyer and you sue your own insurance company, and that's called first-party insurance because it's you're the first party. So you're suing the insurance company to say, hey, you guys are breaking your own contract with me because the contract says you're going to cover the tree on my house. And so if this lady thinks that maybe her insurance company got it wrong, she can sue her insurance company. And then she's like, well, can I sue the mechanic's insurance company? And I said, I really don't think so. And she's like, why? I'm like, because you don't have a relationship with them. You only have a relationship with the mechanic who took your car and took your money, but the mechanic then has a relationship with his own insurance company. So what you would need to do is bring an action against the mechanic, and then the mechanic would turn around and say, hey, insurance company, you guys need to cover me. And maybe they will, maybe they won't. And then that's his own issue on whether or not he's going to get coverage from his insurance company, right? And so it would be his first party insurance claim. So she wouldn't have standing to sue his insurance company, but she would have standing to sue him, and then he could seek recovery. So what I always do in every situation is I say, give me a copy of everything in writing, and particularly in this type of scenario, maybe there's going to be an invoice, maybe there's going to be a statement of work, maybe there'll be terms and conditions, maybe there'll be some really little fine print, and I actually want to see that fine print. I want to see the little stuff, and sometimes it'll be a full page, sometimes it'll be a tiny little paragraph. I'm always amazed at how small and ineffective these types of little contracts are because they tend to miss a lot of important points. So in this particular case, I get the two statements and I'm reviewing them, and sure enough, there's fine print. The fine print does not talk about dispute resolution. It does not talk about arbitration. It doesn't talk about mediation. It doesn't talk about attorney's fees. And these are a lot of times things you'll see. A lot of times you'll have a little clause that says in the event of a dispute, it'll be handled in AAA arbitration in Miami-Dade County using Florida law. And that is pretty common to see that in a consumer agreement. But this one had nothing. However, interestingly, it said that the mechanic shop was not responsible for fire. It said that right next to where she signs her name at the bottom left of the invoice that she was given when she turned over her car, which kind of raises an interesting thing. Like, cars run on gasoline and there's oil, and the fire seems like something that could happen. Doesn't seem, I've actually seen a car on fire before. So it seems crazy that they would try to get out of that. My partner Oscar said that there might actually be Florida statutes, which we have not looked into, that maybe say that you can't waive your liability for fire or negligence in a consumer auto repair agreement. One of my really good friends actually specializes in this, so I ended up referring the case out, and hopefully he gets her a great result. And so just to recap, she probably should have had better insurance in the beginning, right? In the beginning, it's like, yes, you should have had renter's insurance because you're renting the car out, which by the way can be very expensive, but also she should have just normal insurance to cover the property and casualty. And then second of all, you maybe need to be a little bit more discerning when you're choosing your mechanic shop and actually read the fine print and say, hey, really? If there's a fire, you're not going to cover my loss? Like, who's going to cover my loss then? I'm responsible for covering my own loss if your shop causes a fire on my car. So maybe I don't want to go to a shop that is like that. And this is, unfortunately, hindsight is always 20/20. So when you're looking and saying, oh, I wish I hadn't have done that, maybe this is why people need to take more time. So if you guys have any questions or thoughts or maybe your own anecdotes or stories, please share them below. Thanks.